Here in the state of Nevada, the crime of stalking is a very broad category that could encompass anything from misdemeanor conduct all the way up to felony conduct that can subject a defendant to up to 15 years in state prison. The way the law is written is that if you place somebody in reasonable apprehension or terror, or you harass them repeatedly, you could be charged with stalking. The decision as to whether to file stalking as a felony or misdemeanor depends upon what type of threat is alleged to have been made. So if it's just a pattern of harassment, most likely the charge would be a misdemeanor stalking charge. If there's a history of having a prior conviction for stalking, the charge can be filed as a gross misdemeanor. If there is a threat of death or great bodily harm, you could be charged with a felony stalking that could carry a penalty of up to 15 years in state prison. Nevada also has an enhanced stalking provision if you utilize the internet. It requires that you would send text messages or emails in a manner that would, according to statute, substantially increase the risk of harm, which is kind of hard to understand, but it does elevate what might otherwise be misdemeanor stalking into a felony stalking, and it carries a sentencing range of 1 to 5 years in prison. Just because someone accuses you of stalking, however, doesn't mean that the state's going to have an easy time proving stalking. A lot of the time, the charges come from someone that you have a legitimate dispute or argument with, so they might have some motivation to trump up false allegations against you. Usually when a stalking charge comes and I speak to my clients, they have a different side of the story and they say, well, they're saying I did this to them, but look at what they did to me. They might be able to show me text messages or play me phone recordings or show emails that show that the other party was engaged in a pattern of harassment over them. And the law doesn't say that the victim is the first person that reports the incident to law enforcement. It could be that someone would make an allegation against you for stalking because they feared that you might be making a similar allegation. So we're going to want to look into all of the factors that gave rise to the charges in order to determine who the bad actor may have been. Additionally, stalking cannot include conduct that would come within the gamut of free speech. So if you're contacting somebody to express your opinion on a matter, that's a First Amendment right to express your opinion. And you cannot be convicted of stalking someone if you're merely exercising your First Amendment right to free speech. Additionally, let's say you were in a relationship and you broke up with your partner and you left your belongings at their house and you're trying to contact that person for the purpose of arranging to get your belongings back. Well, you have a right to get your belongings back. So if you contact that person telephonically or you send them text messages or emails saying, hey, I need to come by and get my stuff, that would not constitute stalking if your behavior was reasonable under the circumstances. So there are a lot of things that we want to look at in terms of the history between two individuals that might give rise to these types of charges in order to assess whether or not the state is likely to meet its burden in proving a stalking charge. If our client has no criminal history, has never been charged with anything before, there's a really good chance that we're going to be able to negotiate a favorable disposition for our clients, which could include a reduced charge or dismissal of the charges altogether.